Hello, everyone, and welcome to DMH Stallard's Employment Group podcast. This week, we are going to start with the first of a three-part podcast on globalisation in the world of work. Regular listeners will notice that I'm not Adam Williams. I'm Abigail Mayno, another partner in the Employment Group. So we're doing a slight change to format because today's session is all about recruiting talent from overseas, and Adam heads up our immigration team here at DMH Stallard, so he is going to be on the panel. Globalisation is an increasingly important topic, something that's on management radar, and increasingly HR are being asked to advise on and come up with creative solutions to working in a global market. There's an increasing tightening in the labour markets, which we've seen over the last couple of years across various levels and sectors. And the end of free movement means immigration control is more a common issue in recruitment than it ever was. All of that means that employers are thinking whether they look to visa sponsorship as a solution, whether compliance justifies the benefit of that, and how expensive is it to recruit from abroad. And also questions around the sort of activities and responsibilities employers have if they want to benefit from recruiting in a global labour market. So with me to discuss international recruitment are, as I said, Adam Williams, head of the immigration team here at DMH Stallard. Since 2008, Adam has been assisting UK employers to get the most out of the UK immigration system, and he also regularly advises international businesses on the immigration aspects of inward investment to the UK. I'm also joined by Alexei Zoyev, Senior Associate in our immigration team. Alexei has a wealth of experience advising both businesses and individuals on the full spectrum of visa routes and associated sponsorship requirements. He regularly assists businesses with securing work visa sponsorships and individuals with the process of securing their UK immigration status. So, Adam, can you kick us off with a quick summary of what the current state of play is when it comes to UK employers employing individuals from outside the UK?
Yes, hi, Abby. Yeah, I'm happy to do that. And I think probably the best way is to give a bit of a history of how we've got to where we are, certainly in the time that I've been practicing in this area. So we go way back to 2008, and that's when the current, what's known as points-based system came in. Won't go too much further back than that, but listeners who've been doing or operating this area for even longer will know that before that we had concepts of sort of highly skilled migrant programs, work permits essentially, that were much more subjective in their operations. So the beauty there was flexibility in the system, but the downside was the lack of certainty, because in many ways this is a overgeneralization, but you would put a pitch to the Home Office as to why you needed a certain person for a certain role, and that it made sense, and then you would seek to get that permit approved. From 2008, as I say, we had the points-based system come in, and that came in within the wider aim. Obviously, it's a highly political area, but there's a wider aim of reducing net migration, which we all know, even up to today, is a repeating theme through politics, and certainly the current incumbent Conservative government. But actually, though, it was based only loosely, but on research done on the Australian model, which is a great system generally, but particularly if you want to increase net migration, not reduce it, because we went from a system that was much more subjective, as I described, to one that was based on satisfying eligibility requirements. And what tends to happen is, once people know that there's a binary set of attributes they need to demonstrate to get the visa, well, you just work out a way to achieve them. So there's always been this conflict between the system we use since 2008 and the broader political ambition of reducing net migration. And that's actually been never more apparent than it is now, with the stats we had a week or two ago, net migration being at sort of all-time high levels, as against the desire to bring numbers down. What we've obviously had looming large in the last couple of years is also Brexit. So, you know, the points-based system was very important as a mix, part of a mix of options for recruitment running up to Brexit. What's happened since Brexit properly was implemented, and it was the ending of free movement. So suddenly, not all of these people are working age, of course, you've got about 500 million people within the EU who moved from free movement. And the examples we had back in the day where you find a really good candidate in Paris, you'd tell them to jump on the Eurostar and bring their French passport, and you'd check their passport and they'd start work straight after that. To that whole block becoming subject to immigration control as well, unless they had legacy links to the UK or were a frontier worker. Maybe we'll touch on some of those examples later. Alexia may talk about those. So suddenly the immigration system and immigration control became all the more important. And I suppose that's been the big recent shift. So the state of play now really is, we've still got the points-based system. It was changed materially, but not in a revolutionary way after 2020. And it's now it's looming much larger in our landscape, because anyone who doesn't already have an automatic right to work and live in the UK has to be brought within it. So that's the nutshell. The other thing I just quickly say is the trend within visa sponsorship in the UK and the points-based system is towards sponsorship. Over time, the categories with which you might have someone come to the UK and take up a job or be self-employed without a formal visa sponsor, typically a UK-based employer, they've just reduced over time and continue to reduce. So the concept of having at least one formal sponsor with a license has become much bigger. So I guess that's a big part of what we look at as a team now, is looking at sponsor licensing, looking at the eligibility criteria, trying to get ourselves within those points-based routes.
Yeah, that's really interesting, Adam. And I've certainly sort of anecdotally from my own practice, I've got many more clients now talking about recruitment from overseas, and purely because of the tight labour market. Well, not purely, but often because of the tight labour market in the UK, and where they may have looked to Europe, that then isn't as straightforward as it used to be following Brexit. Alexi, faced with all of that, and it seems like there's been a lot of shift over the last few years, how does a UK employer decide whether or not sponsorship is the best route for them?
Well, Abby, assuming there are no viable immigration options outside of sponsorship, employers first need to establish whether the role is eligible for sponsorship in the first place. To be eligible, the role must meet the minimum skills and salary threshold. If the role is eligible, the next question is always about the cost. Sponsoring workers can be fairly expensive, especially if someone is being sponsored on a long-term basis. Sometimes employers are also asked to cover these application fees for their company independents, which can be a considerable additional expense. Some job applicants are also subject to the immigration skills charge. In such cases, employers have to pay around £1,000 per year of sponsorship. This is if they're a large company, or £364 per year if they're a small company. Together with the other charges, which include visa processing fees and the immigration health surcharge, the cost can be prohibitive. First thing that I usually do for my clients is check whether the company can benefit from any exemptions. For example, some applications or some applicants could be exempt from the skills charge based on their age or based on their immigration history. So, for example, if they're switching from a student visa, they will likely be exempt. So it could be a lot cheaper for a company to sponsor someone who's already in the UK with a student status. Also, certain shortage occupation roles are eligible to reduced visa processing fees. So there are a number of things to take into account in respect of costs. And then if the client is happy with the cost, then the next question is usually about the length of the process. Quite often, employers need their candidate to be able to start their new role within a short period of time. If the company does not already have a sponsor license, the end-to-end process could take from a few weeks to several months. There are, of course, ways to speed up the process, but these options are not available in every single case. So each scenario needs to be assessed individually. If the estimated timeline is acceptable to the business, then the next question is usually about the additional duties and risks associated with becoming a licensed sponsor. Guess it's important to say that in the eyes of the Home Office, being able to sponsor workers is not a right, but a privilege. And the Home Office
Mm,
expects the licensed sponsors to have a higher degree of commitment to applying the relevant laws and regulations. In particular, sponsors must strictly follow the rules aimed at prevention of illegal working. So when deciding whether sponsorship is a suitable option for the business, prospective sponsors need to ensure that they have the capacity and the relevant HR systems in place to monitor their compliance with the relevant obligations. As long as these two things are in place, then sponsors will enjoy all the benefits of being able to hire being able to hire migrant workers. Um, when advising clients on sponsor license applications, we are able to evaluate their existing systems, identify any gaps, and make
mm.
recommendations. And usually with the correct guidance, it is not actually that difficult for an established business to bring their HR system in line with the requirements.
Yeah.
So I guess in summary, the
Mm.
key things that employers need to think about when deciding whether sponsoring workers is a viable option for their business model include cost, the time it is going to take to bring a migrant worker on board, and also whether the company will be able to fulfill the additional compliance obligations associated with becoming a licensed sponsor.
Yeah, thanks, Alexi. That's really, really helpful as an overview, because I think a lot of employers associate the sponsor license route purely with the cost, and that might be the first and principal thought they have. But actually, there could be some benefit in thinking longer term about the talent that they might need to recruit, and looking at some of those compliance things, and time period that it might take to be a licensed sponsor, um, well in advance of when they need or may want to bring someone in and be a sponsor, a licensed sponsor, um, is what I guess I'm hearing from you. I mean, I wonder, Adam, are there any other less obvious benefits to becoming a sponsor other than the obvious ability to bring that key person to the UK from another country? Is there anything else that having that license, that sponsor status, would be a benefit to the business?
Yeah, there are. I mean, I was listening to what Alexi was saying there, and I think that's all really important. And one of the things that comes through from that discussion is, when we're talking to organisations, I think it's important to think about, just quickly before I will answer your question about the other benefits, but about the scale. A lot of sponsors come to this. Well, no, sorry, a lot of prospective sponsors come to this thinking about one individual,
Mm,
and that's fine. But that analysis of risk reward and cost benefit is different when you're looking at one individual. And I think we're of the view, think about scale as well, though. Think about whether you would still want to go ahead if you were going to do this at scale, because lots of sponsors end up getting a license, bringing one individual in, and they realise that there's benefits, and they end up doing it a lot more. Because the thing you don't want to do is have done an analysis that says, well, our system is sufficient to comfortably look after and meet our compliance duties for one sponsored individual, and in 3 years' time you realise you've got 20, and you haven't had a conversation with yourselves internally about whether we're still fit for purpose. And to be
mm,
honest, if you've got a system that just about copes managing one sponsored migrant and you've ended up with 20, you probably don't have a system that works. So we try to look at those two things, but it links to your point, because there is scope for other less obvious values from having the license, but they would drive the increase in the scale and volume you're doing. Really around kind of employer of choice, I guess, in choice benefit, and being as a more attractive in the marketplace. And it's really about the local labour workforce, but I mean that in the broader sense of people who are already in the UK. They're
mm,
subject to immigration control, but they're already in the UK. So, for example, if you're already a visa sponsor for skilled worker visas, well, anyone who's graduating or recently graduated, they might be on a student route visa or a graduate route visa. Well, they immediately know, and you can go to the jobs market putting out there that you are able to sponsor them in a switch to skilled worker. And that's really important for an individual, because
mm.
they're in a route that doesn't count towards indefinite leave whilst you're a student or a graduate. And suddenly, if you see this employer with a license, they can see, I've got a long-term future career potentially in the UK with that sponsor.
And one question that our listeners may have, which may be an obvious question but may not be, do you have to, when you're becoming a licensed sponsor, and it's linked to your point about attracting talent within the UK that might be subject to immigration control, do you have to apply to be a licensed sponsor in connection with one or more individuals that you're going to employ, or can you do it prospectively and say, I may want to engage individuals in the future and I'd like to become a licensed sponsor?
I think that's one of the shifts. You always were able to, in theory, apply for a license if you didn't have one particular person in mind. But going back a few years, we tended to be advising that there is a risk that the UKVI are going to come back and go, we're not really sure we understand why you need the license. Is this just speculative? When Brexit started to happen, that loosened up a lot more because, of course, organisations could genuinely say, look, up until the proper Brexit date, we were employing people in Europe as and when we needed. We're anticipating a need post-Brexit to use a sponsor license for that. And in fact, what the Home Office did, they went out and encouraged employers to think about that and not wait, because they didn't want the tsunami. And they have actually got, maybe not quite a tsunami, but they have had this huge wave of sponsor license applications after Brexit with organisations who went, oh, actually now they've reacted when they felt the pinch of it. But, oh, hang on, no, we can't bring that person from Madrid then. No, you need a license. And that's Alexi's point as well about there's a lead time for licensing. So that is an important point, really, that you can apply on the basis that we will have a need. You just, I guess, Alexi, you probably feel this way. You just may be more likely to get some additional questions back from the Home Office about just understanding exactly, particularly if you're not very specific about the types of role that you are envisaging sponsoring. If you're just like, can we have a license, please? That's probably going to, at the very least, garner some extra questions from the Home Office, and you probably haven't complied with the information requirements that you have to put in when you apply. What do you think, Alexi?
Every time anyone applies for a sponsor license, they always need to justify the need for that license. So whether or not they have identified a foreign worker that they would like to sponsor, they need to submit supporting documentation with their application. Based on that evidence, the Home Office will take a view on whether the business is likely, even if at the point of application they haven't identified anyone to sponsor, the Home Office will take a view on whether, based on the evidence, the company is likely to need to sponsor foreign workers in the future. So for some business, especially if for example, it's a new business that's been set up in the UK, but it's got links to a parent company outside of the UK, then chances are that that company will need to bring people over and the Home Office will recognize that. If it's a completely new company set up in the UK that does not have any links to overseas, then the Home Office may be a bit more skeptical and may want to see additional evidence. Because if it's not an established business that has been trading for a while, then what the Home Office does want to avoid is, dodgy companies being set up with a view to facilitating people coming to the UK using the sponsored route.
I see. Yeah. So it sort of suggests you can be a little bit proactive, but you've kind of got to get your ducks in a row a little bit about why you may need to look to a sponsored worker or a worker that might be subject to immigration control, rather than individuals who have the right to work in the UK. So perhaps, I don't know, maybe a bit of an analysis about gaps in your labour resource and the types of people worldwide that undertake those roles, whether there's a shortage in the UK, etc. Very interesting. So, Alexi, if visa sponsorship isn't an option for whatever reason, what other potential routes are there for individuals to come to work in the UK? Are there any?
Well, when I'm approached by clients who have identified a foreign worker that they would like to hire, the first thing I do is to check if there are any other cheaper or otherwise more attractive or suitable immigration routes than sponsorship. For example, if the candidate is from a Commonwealth country and are below a certain age, they may be eligible for a 2-year youth mobility visa. Some other Commonwealth citizens may also be eligible for a 5-year ancestry visa if one of their grandparents was born in the UK. Within the IT industry and the academic sectors, a global talent visa may be a good alternative to sponsorship, provided that the applicant is a leading specialist in their field or a young professional showing exceptional promise. Another interesting category that was introduced not so long ago is high potential individual route. So graduates from some of the world's top universities may be eligible for this visa. And it can be granted for up to 3 years, depending on the candidate's degree level. If the business is looking to hire an intern, on the other hand, then they may be able to use one of the existing Tier 5 schemes. Each scheme has their own requirements, and the employer will need to get registered with the provider before they can use them to sponsor someone. But when they use those external schemes, they do not need to be a licensed sponsor. So they
I
will
see. And
basic-
sorry, Alexia, are they linked to particular types of work then? The organisations that run those, are they
not necessarily.
sector
So if
specific or no?
some of them are, so there are many different schemes around. Those schemes are licensed by the Home Office to act as an overarching body when sponsoring interns to undertake internships at different companies within the UK. So what happens is that the scheme administrator, they will obviously apply the rules and ensure that all the sponsorship obligations are fulfilled. And the way they usually achieve that is by requiring the businesses to register with them and to provide them with updates and the relevant documents in respect of each individual. But what happens is that those Tier 5 schemes act as a sponsor, but the person is not working for them. They will be working for a company that is registered with the scheme. So that way, the company that wants to hire an intern, they do not need to apply for a sponsor license in their own right. They can kind of outsource the sponsorship bit to one of those licensed Tier 5 scheme operators. But it can be pretty much in any industry, so it doesn't have to be sector specific. There are sector specific schemes, but there are also schemes that cover all the industries. So as long as the
Right.
company is able to meet the requirements, then they usually can register and use the scheme.
Yeah.
Probably
Yeah.
worth mentioning, Abby, are two things around the scheme as well. It's some of them, with their sort of membership requirements, require the employer that wants to ultimately have the migrant to already have a core sponsor license of their own.
Yes,
they're kind of using that as a way to filter out and not only let people who've the UKVI have already kind of vetted in. Not all. I mean, it's probably in the minority, isn't it, Alexa? The number
yeah,
that do
it's the
that.
case. One of the schemes that comes to mind is the Law Society Tier 5 scheme.
Yeah.
That scheme is aimed at overseas lawyers that want to come to the UK to gain experience or share experience, and each scheme can introduce the requirements of their own. So ultimately, they need to make sure that they fulfill the compliance obligations. And some scheme operators tend to introduce more stringent requirements than the others. So Law Society is one such example.
Yeah, and the other area is that through these scheme arrangements, they're almost uniquely juxtaposed to the normal position, the very restrictive position under the main worker route, not temporary worker, but skilled worker route of this relationship of employer as sponsor and having control and supervision over the individual. It's important for our listeners to appreciate that these T5 overarching schemes are juxtaposed to that, and it's important not to get the sense of that's okay, because if you become a sponsor yourself of work visas, there are very strict restrictions around you sponsoring someone and then sending them off into another organization, third party. It's got to be time bound, has to be supervised by the sponsor. They're very different pictures. So that's part of the benefit of this one. If you need someone but you can't do the sponsorship yourself, this would be a route. What wouldn't be possible is you find another UK employer who's got a skilled worker license and they act as an employment business and they go, we can get the person in, get them a skilled worker visa, and you can just have them. It's really important, particularly if you're the person saying that, not to do it. But even as the recipient, you don't want to be found to have been taking someone on when they're sponsored by someone else in that sort of context. But it's a really good option to look at, because you
Yeah.
can avoid a lot of compliance burden. The other thing, just quickly, was on the employer of choice side, the HPI route, the high potential individual route that Alexia mentioned. That's like an extension of this thing about being attractive in the recruitment market, because it's like a graduate route visa, but it's international. So you could go to one of the big top 50 universities. Let's just pick Stanford in America. If you know there's a cohort of people with coming out of that university or have come out in the last 5 years with the right skills, you as a UK employer are able to say to them, well, you can just get this visa under HPI, but we're also a sponsor. So you're not coming over for a short time and have to turn a tail and go back. You could start a career here with us. So again, that's the indirect benefit of being a skilled worker sponsor, internationally doing international milk rounds effectively.
Yeah, well, it does sound like there's a lot of options that perhaps our listeners aren't aware of. I mean, certainly some there I wasn't aware of in terms of the options. If you're not a licensed sponsor for whatever reason, and the benefit, I think it just comes back to just the organisation of thinking about what you might want and when and the different options, and the value of talking that through. Because actually, I think a lot of our listeners would think, well, we have to be a sponsor holder or that's it. But actually, there are loads of other potential routes in to explore, which may be better for that organisation, not least because it might be more cost effective, but it might actually attract the type of talent that they're looking for. But if they do want to go down the sponsorship route, Adam, what's the process, just in outline form now, in terms of what it looks like for becoming a sponsor?
Yeah, I mean, the thing to just mention first is not to give people the wrong impression that it's really, really straightforward. I don't want to oversimplify this, but in outline, I mean, in its core stages and activities, it is quite straightforward to describe. It's the work that goes on behind these steps that's important, I guess. So we've talked about the analysis stage, which Alexia talked through, the things you think about as an employer about, how are we looking to use the license? Who would we be looking to sponsor? In what roles are they eligible? You do that analysis, you make sure that you're committed to taking this leap. And if we looked at the most common route, which would be skilled worker, so that's under the worker categories, not the temporary worker. Essentially, the license application process is two key things: gathering of key documents from a specified list, and you've usually got one or two mandatory types of document that the process is saying you must provide, and then you can choose. Often it's two or three that you need to pick from a set of potential, and that's typically things like maybe a proof of your bank account, corporate UK bank account that's regulated, a PAYE registration, things that demonstrate that you're a bona fide, proper established employer in the UK. There's the preparation of the information we touched on earlier. It's usually by way of a supporting letter around why you want a license, what sector you're in, what are your working hours arrangements, which roles would you be looking to sponsor, demonstrating that you can be trusted to be a sponsor and that you understand the things you have to show in order to validly sponsor someone. So that's usually the things we say once you've done the analysis. Get working on those straight away, because it can take some time to get those documents together. Something's got to come from an accountant, or maybe it's from the bank. And then alongside that, there's the preparation of the online application form for the license, which, if you knew all the information you needed from the outset, would not take very long. And it's pretty fact specific about the business, again, about its sort of sector types, about the size of the employee base, the routes it wants to sponsor in. But there are some bits there that get a little bit more technical around explaining your need for undefined certificates, which are the UK-based sponsorship certificates. How many do you need and why? You have to fill that out. And alongside all that process, you've got to identify some key personnel. The big important one will be the authorising officer, who can also act as a level 1 user. The level 1 user is the functional role on the sponsor system once you've got your licence. But you need to have a UK-based employee or officer to act as essentially the face of your organisation with the Home Office, the authorising officer. They can't have certain criminal background, bankruptcy stuff in the background, that you've got to pick someone. And that involves, of course, a discussion internally, because it's not a role anyone should take on lightly. With particularly with external support, you can manage the kind of workload that goes with it, but you need to identify those key individuals. You put the license in. You now submit supporting documents by email once the online application's gone in and you've paid your fee. And then you're either, as Alexi touched on earlier, you're trying to get a fast track place and pay £500 to get your license application decided within a couple of weeks, or you're waiting potentially 8 is the standard servicing turnaround time, but maybe more, to get that license decision back. And what can happen during that waiting period, it could happen whether you get a fast track place or not, is you could get no further contact. The next thing you hear is a letter going, congratulations, you've been granted a license, here's your details and access arrangements. Or you could get a request for information. Usually comes in a table form where they're saying, we want you to give us this, this, and this more information. Or, this requires more resource from the Home Office, so it's less common overall, you could get a visit. Clearly, the Home Office want to have a sense that they're checking and making sure that applications aren't made from completely fictitious organisations. They have in the past gone to do a visit and knocked on the door of the address that was given and found it's a newsagent's, and the people at the newsagents have no idea what the company name is they're talking about, and they realise that this was an attempt to create illegal migration through a fake employer that doesn't exist in that sector, doesn't have that. So you can get a visit, and those visits could happen after you've had the licence as well, of course. But you go through that process, and if successful, you're given a 4-year license. That's probably it in a nutshell.
And do employers get, if they are going to get a Home Office visit, is there any warning of that? Do they have to give warning?
They don't have to. Almost always. I mean, this is shared experience within the team, so Alexi can give his view as well. But they don't have to. But almost always, you would get some warning. The time they wouldn't is if they suspect that there is illegal working and they need to effectively raid the organisation, which would be very unusual in a pre-license, if you know what I mean. You've applied for a license, because if you're in sort of dawn raid territory, they don't normally put themselves on the radar applying for a sponsor license at all at that phase. So normally you would get notice, but it can be very short. Sometimes you don't get much notice. Alexi, I think it can vary.
So the Home Office have what they call as unannounced visits, and then they also have announced visits. Every year they have a certain number of businesses that they want to visit as part of their usual process, just to make sure that the businesses are compliant. And then in those circumstances, they contact the company in advance, and in fact, they can offer the company a number of specific dates, and basically they can accommodate the business and visit them at the time that is convenient for the company. As far as the unannounced visits are concerned, so as Adam mentioned, they usually relate to instances when the Home Office suspects that there could be illegal working going on, or that the company is likely breaching their other immigration obligations, so that in those instances the Home Office may show up on their doorstep unannounced. If that happens, it doesn't mean that the audit, the check has to happen on that day. So, for example, if the authorizing officer is not available to answer the Home Office's questions on the day, then they may ask the Home Office to come back at another time. Obviously, the situation would be different if the Home Office strongly suspects that there is illegal working going on, in which case they could just start conducting checks on staff on the day. But in other circumstances, they're usually quite happy to accommodate the business and rearrange the visit if it seems to be reasonable in the circumstances.
I mean, it's just, it does all come back again to those organisation of records, because if you've not got too long before the Home Office comes out, you're really going to want your systems to be up to date, up to scratch, and for that authorising officer to be able to call on that to answer any compliance questions, particularly going back to what was said earlier about it being a privilege and not a right, and that evidence of compliance with that duty to prevent illegal working. Well, it sounds like there are a few steps to get the license, and I guess, call me cynical, I guess once you've got the license, it's not the end of the process. Um, is there anything, Alexi, that has to happen after you've got the license?
So once the sponsor license is in place, there's a separate process that will need to be followed for each migrant worker to secure their skilled worker visa. The process will be different depending on whether the worker is switching from another visa within the UK or applying from overseas. For those based outside of the UK, a defined certificate of sponsorship will need to be requested from the Home Office under the company's sponsor license.
And how long does that take? Does that take a long time?
So these requests are processed within 1 or 2 business days in the majority of cases, but they can, the Home Office can request additional information, in which case the process can take considerably longer. Usually when you submit your defined cause request, you must include the details of the role, including the length of sponsorship required and the salary, as well as other information. And then with certain roles, the Home Office tend to conduct additional checks. So depending on the SOC code that you have mapped the role to, certain SOC codes
And
require
sorry,
additional
just to
scrutiny,
cut across
basically.
you there. Sorry, Alexi. SOC codes. When we're talking about SOC codes for our listeners, what does that mean? What does that stand for?
So those are basically standard occupational codes that are published on the government website. So any particular job type has a brief description on the government website. And when you have a particular role that you want to sponsor someone for, you need to identify a suitable SOC code. So you just need to match your role with one of the roles published on the government website. And then once you've matched the roles, then that tells you the minimum salary threshold and the hours on which that salary is calculated, so you could determine whether your role qualifies for sponsorship. Right, and then once a defined certificate of sponsorship has been received, then the company will need to assign it to their selected candidate, and then the candidate must apply for their visa using that certificate of sponsorship within 3 months. Applying for a visa usually means that the applicant must attend an appointment at a visa application center and submit their passport. Processing times for a skilled worker visa are usually around three weeks, but it is often possible to reduce these to about 5 working days by paying a bit extra for the priority service. EEA nationals who have a biometric passport are also eligible to apply using a fully digital process, which involves them downloading a Home Office app to their phone and then verifying their identity using that app. The processing times are the same, basically whether you apply with an appointment or using the app. The advantage of applying, and EA nationals have the option of using either of those routes. So if they have a biometric passport, they can decide which one to use. If they don't have a biometric passport, then they need to apply in the standard way with an appointment. And the processing times are basically, as I said, the same, whether you apply using the fully digital route or whether you apply with an appointment. The only difference could be the waiting times to get the actual appointment. So if you use the app, then you can verify your identity straight away, and then the processing of the application starts from that point. If you need to book an appointment, then there could be 1 or 2 or 3 week waiting times before you get your appointment, and then the processing technically starts from the date of the appointment rather than the date on which you book one. So that could delay the processing slightly if there are no appointments available immediately. For in-country applications, the process is slightly different. Unlike applicants who are based overseas, migrant workers who are already in the UK on other eligible visas will not require a defined certificate of sponsorship. So the sponsoring company will need to use an undefined certificate of sponsorship from their annual allocation of certificates of sponsorship. Each company is given a set number of undefined certificates each year, and the number is usually based on what they used in the previous year. So if they assigned five undefined certificates of sponsorship in the previous year, the Home Office tends to grant the same number in the following year. And then if the company does not get any because they didn't assign any certificates in the previous year, or if they run out because they need to sponsor more workers this year than they did last year, then they can apply for additional allocation. And that request will need to be submitted first before they can assign an undefined certificate of sponsorship to a prospective new hire. And then once a certificate of sponsorship has been assigned, then the applicant will be able to proceed with their visa application. The majority of skilled worker visa applicants who are already in the UK can currently apply using the digital service that does not require them to attend an appointment. So they, similarly to out-of-country applications submitted by EEA nationals who can use the Home Office app, skilled workers who are switching employers or are extending their skilled worker visa within the UK and have a biometric residence permit can use that biometric residence permit to link it with the Home Office app and verify their identity that way. And then if for any reason they're not able to use the digital service, for example, because there's a fault with their biometric residence permit, then they need to attend an appointment. The processing times at the moment standard processing times for in-country applications are about 8 weeks, but the majority of applicants tend to use the priority service, which offers a decision within around 5 working days. And also those applying with an appointment can also opt for a one-day super priority service.
Yeah, and I think that links, Abby, just to do a key point around we talked at the top end about employers looking at and individuals looking at costs, and something that's worth looking at early on, particularly if there's a time scale to be met, is what the options and costs are for priority services, that side of things. And then who's bearing that cost? I mean, it strays us over into employment law rather than immigration law, but if the company is going to bear some, organisation is going to bear some of that cost, will that be under any sort of clawback arrangement? And that can get slightly more complicated in this context than just a general sort of training contribution towards training, because certain of these costs you can't claw back from the individual, certain you can, but you know there's these factors to try and put into the plan as early as possible, I think, because then you're preempting the need and you're not finding that cost pops up unexpectedly later on.
Really interesting, and obviously something that needs to be factored in terms of the timescale and cost of bringing someone in once you've got that sponsor license, because particularly if you're going for some sort of priority entrance. I've just got one final question, if I may, and that's really a kind of, how creative can employers get with these visa routes? What sort of flexibility is there in the different types of routes? So, for example, could you, I don't know, have someone working part of their year in the UK and part of the year for the same employer abroad? Can they continue to be paid by that non-UK employer? To what extent can you, and bearing in mind, you know, the increased globalization and employees wanting to work remotely and in different locations, can you do that as a sponsor? Maybe Adam, if I come to you first for your thoughts.
Yeah, I think that's one of the key points. It's one of the key things that we do working with organisations strategically is about this area of being creative. I think my broad view and message is, don't think too much in sort of narrow confines. Do be creative, and you know we have far too many different visa routes and combinations of routes. Really, it is difficult to manage in that sense. But one of the benefits from that is that there are a multitude of different routes, and even within routes there are options. So the answer is yes. In theory, you could have someone working, partly in the UK, partly abroad. Yes, in theory, you could have someone being paid out of a non-UK entity or bank account. There's lots of different flexibility around the system. It's just having the ability to sort of take the helicopter view, I guess, really. And it's easy to get sucked down the obvious route and then go, oh, that doesn't really work, or it's too expensive, or not attractive for us, and miss that there are other angles. It's really what Alexi was talking about at the top end of the session, really. Keeping your mind open. There may well be hidden angles that you can pull on to get that outcome.
Mm. Yeah, absolutely. Alexi, is there anything that you can't do? You know, for example, I'm sure there's plenty of things you can't do with these visa routes. Are there limits to the flexibility? I mean, I know we touched on earlier about not being able to farm out your workers to different entities. Is that an issue?
Yeah, so the important message is that the role must be genuine. So the sponsor license must not be used to facilitate entry to the UK in cases where the business does not actually require the person for
Mm,
the job in question. So
mm,
jobs must not be created with a view to sponsoring someone for a visa. But other than that, if there is a genuine need uh, to fill a particular role, then there are a lot of different options for sponsors. And as Adam mentioned, there are things like payroll being administered outside of the UK, and these are typically the things that a lot of sponsors don't think are possible, and they may not even start exploring certain options within the sponsored route because they assume that this is not going to be possible. But
mm,
before, so my message to our listeners is that before you make any conclusions, it's best to consider each scenario on its own merits, and then
mm.
chances are that we will be able to find a workable solution.
Mm, that's really interesting. Thank you. And I've definitely learned a lot today about the importance of planning, and not just thinking it's a sponsor license or nothing. There are there's seemingly lots of different and creative approaches to recruiting candidates from overseas that perhaps our listeners hadn't thought about today. So thank you, Adam and Alexi, for those really valuable contributions. As I said at the start, this is the first in a three-part series on the globalisation of working. And the next session we'll be looking at whether employees should be allowed or encouraged to work abroad or whilst on holiday or whilst they wanted to spend some time outside of the UK for whatever reason. Should there be any limits on that, any policies around that? What are the pros and cons of that for the organisation? And then we'll be ending the series with looking at any issues or considerations with engaging employees to work abroad on a more permanent basis, and looking at things like payroll and tax issues and other legal implications. So do follow us on LinkedIn, Apple Music or Spotify to get those updates. But all that remains for me to say is thank you again to Adam and Alexi, and we look forward to welcoming you part 2 of the series.